All rise. The Honorable Chief Justice and Justices of the Supreme Court. The Honorable Supreme Court of the State of North Dakota is now in session.
Please have a seat. We'll call file number 2021-0280, Donna Mae Wald versus the Honorable James D. Hovey, Judge of the District Court, Southeast Judicial District, and Gerald Wald. I'll note the appearance of Rodney Pagel on behalf of the petitioner, Donna Mae Wald, as well as Mary Batchelor on behalf of the respondents. Mr. Pagel, whenever you're ready, you can approach the podium and begin your argument. I see that you've reserved 10 minutes for rebuttal, so you'll have 20 minutes before it signals your time.
Thank you, Chief Justice. May it please the Court, Chief Justice Jensen, opposing counsel. My name is Rod Pagel, and I'm representing the petitioner, Donna Wald, in this matter. This is a matter before the Court on a petition for supervisory writ filed by Donna Wald as a result of a demand for change of judge having been denied in this matter. The underlying scenario of this case is that the parties to this matter, not including obviously Honorable Judge Hovey, Donna Wald and Gerald Wald were divorced in 2019 after a district court judgment was entered. An appeal was filed by Ms. Wald. A post-judgment motion for contempt and redistribution of property occurred in the midst of that appeal process. That resulted in this court sending the matter back down to the district court to address that post-judgment motion. That post-judgment motion was then denied for contempt and redistribution was denied by the district court. That was also appealed. Upon appeal of both the judgment and then the post-judgment motion determinations, this Supreme Court upheld the district court's decision in that matter. Those scenarios occurred in 2019 and 2020. Following all that appeal process in the context of the divorce case and there being a final judgment entered, the scenario that existed then and which exists today is that Donna Wald has been awarded $242,000 in hay bales, and of those hay bales, she has not received one of those bales. Certain facts, I believe, are present and indisputable. The fact is that the divorce court awarded her absolutely those hay bales. The divorce court also found that absolutely that Gerald Wald was not in contempt for not turning over those hay bales, not in contempt in the context of the divorce judgment, and that Donna Wald was not entitled to redistribution, and that was not appropriate because the trial court determined, and this court upheld, that she had not shown that Gerald did not comply with the court order as required by North Dakota Century Code 1405-24-3, which would have allowed for redistribution. Certain facts are also, I believe, clear that would allow for her claim to continue forward, which is that there was no determination made that Gerald Wald had a right to keep that property. There was a determination made that he was not in contempt. There was a determination made that he did not, found that there was should be no redistribution because there was not a determination of lack of compliance. But there was no determination made that he was entitled to keep that property. At the time of the divorce judgment being commenced, there was no claim and no right to have a claim for unjust enrichment or tortious conversion, which is the claim that Donna Wald subsequently filed after the entire appeals process through the divorce case. When this court also remanded the case back down to the district court, the remand was very specific in its limitation and terms. The remand indicated that it was remanded for the limited purposes of determining the motion on contempt and redistribution of property. No other issues were to be determined by the district court in the context of the remand. Because of that scenario, following all that, Donna Wald commenced a distinct and separate action against Gerald Wald based upon unjust enrichment and tortious conversion. Those claims, we assert, are separate and distinct from the divorce case. No claim or basis for a claim existed of any nature until judgment in the divorce case had been entered. And once judgment has been entered in a case, Donna Wald could not then go back and try to amend her divorce case complaint to allege unjust enrichment or tortious interference. No right to an action occurred for unjust enrichment or tortious interference until that divorce judgment had been entered. And she could not bring, in the context of the contempt motion, could not return back to court and remand this back to court because of the limited and distinct, the limited terms of the remand coming back down to the district court. Again, that all resulted, and the reason that's important is because it all resulted in Donna Wald filing a separate and distinct action for unlawful conversion, tortious conversion and unjust enrichment. In the context of that case then, once the district court had assigned a judge, Donna Wald, as a separate right under that, her current action, had a right to demand a change of judge under North Dakota Century Code 29-15-21, particularly looking at subpart 4 of that section, which is the primary language which is in dispute in the context of the current petition for supervisory writ. That section states that the demand for change of judge must state that it's filed in good faith and not for purposes of delay. It must indicate the nature of the action or proceeding, designate the judge sought to be disqualified, and certify that the judge has not ruled upon any matter pertaining to the action or proceeding in which the moving party was heard or had an opportunity to be heard. The action or proceeding that we are talking about today is an action for unjust enrichment and tortious conversion. It is not an action for divorce. That action was decided and determined. This action, the action for tortious conversion and unjust enrichment, was only commenced by service of the summons and complaint upon Gerald Wald following the divorce case.
Mr. Pagel, could you back up a few words in the statute? I understand what you're reading, any action or proceeding, but what about has not ruled upon any matter pertaining to? What does that mean?
Justice, I believe we have to read that certainly in context of the entire sentence. Any matter, that matter must pertain to the action or proceeding.
Wait, you came here, and I'm interrupting, so I apologize, but you came here telling us about the divorce, as if it's necessary for us to understand about the divorce to get on to the new action. So how is that not a matter pertaining to?
Yeah, I think it's a matter, the issue is whether it's a matter pertaining to the divorce or it's a matter pertaining to the unjust enrichment claim. And I'll pick on just the unjust enrichment claim. If it's a matter pertaining to the divorce, and it's decided in the context of the divorce case, I agree. I think it's game over. If this is a motion for contempt against Gerald Wald, it's game over. If it's a motion to amend the judgment, it's game over. She is stuck with amend the property. We have distinctions in the context. There was no children here, but if it's a motion of that nature to amend anything related to the divorce judgment, I certainly agree that in that situation, Donna Wald does not have a right to demand a change of judge in that scenario. The matter, this is whether or not the judge initially appointed had ruled on the matter pertaining to the action or proceeding, which is this action or proceeding that Donna Wald has commenced.
But wouldn't your position, if we take it to the logical conclusion, any case, divorce, any other civil case where there's a judgment, and the judgment creditor moves for contempt, and the judge denies the contempt order, and there's an appeal, and the contempt order is affirmed on appeal, the logical position would be is, well, then you can just start a separate action for unjust enrichment or tortious conversion. That's the logical conclusion that would come from this case, is you can essentially lose your enforcement in the actual case and just start a new action.
I think if that action is associated with the failure to turn over property,
But that's what you're doing. You're really just enforcing the judgment. I mean, you've couched it in terms of unjust enrichment, and it's couched in terms of tortious conversion, but it's really just it all arises from enforcement of the judgment.
There's a judgment in,
It has to, I mean, that's where it stems from.
I agree, there's a judgment in place that says she's entitled to the bails.
How, do we, in any other context, have we ever recognized that you can start a separate cause of action to enforce a judgment in another case?
Not that I'm aware of, no. But I don't think this court has declined the right to, also to enforce that judgment, to enforce the rights under that judgment. So
Well,
I
that
think
was my
there's-
question. Is this an enforcement of the judgment, or is it, what you said last, to enforce the rights or to obtain the property received under the judgment?
And I agree, the intent is that there's property that she hasn't been entitled to. The district court in the divorce case determined that, again, I think there's a distinction that the district court didn't say she's not entitled to those assets. The district court says he's not in contempt for turning over those assets. And I think there's a great distinction there. Because the district court says he didn't do anything wrong in not turning them over because of the context of that judgment and the language of that judgment. But it didn't say he's entitled to have those assets. And if he's not entitled to keep and have those assets, those were absolutely awarded to Donna Wald. Now, he may not be in contempt, but Donna Wald then has the ability to, under an unjust enrichment claim, and that's to be determined, I guess, in the context of the viability of that claim hasn't been determined yet by the court, and this is the initial salvos and stages of that process. But our position is that she still has, that's an asset that was awarded to her. The court didn't take that asset away from her. She still has that asset. It was awarded to her. It's just that he wasn't in contempt for not turning it over.
Mr. Pagel, your demand for change of judge is based on statute and not bias, actual bias?
It's based on statute, yes. Yes.
And what says that you have the right to a supervisory writ to begin with?
Well, I believe there's pretty clear case law, Justice Vanderwall, that gives Donna Wald the right to file a supervisory writ. Probably the seminal and primary cases in Traynor versus Leclerc, 561 Northwest 2nd, 644, in which a similar type of scenario occurred, and this court ruled that it is appropriate to file a supervisory writ when a demand for change of judge has been denied or ruled upon it presumptively improperly, and that case has not been overturned.
Well, from what you've described, you've not said that was a Judge Nerman want to replace as biased. How do you know he won't accept this argument? He understands better than anyone what he intended in that divorce decree.
He may accept the argument. He may allow the unjust enrichment claim to go on. That could be the scenario. Nonetheless, Donna Wald made a determination that she desired to seek a new judge, and per statute, she had the right to seek a new judge, since this was a separate and distinct action or proceeding, and no other matter had been ruled upon. I mean, she asked for a demand for change of judge, I think within 3 days of the judge being assigned in this case, and he had
Well,
not.
you've read the case, I assume, that opposing counsel submitted this morning. We saw it. I saw it for the first time. What's your response to that as far as a separate action is concerned?
Yes, I mean, there are three primary cases in which opposing counsel cite to in the response and brief: State versus Zuger being one, Giese versus Giese, and then now yesterday, Falcon versus State. I think though all of those are very clearly and easily distinguishable. The most recent, to get directly to your question, Justice Vanderwall, Falcon versus State was a criminal case in which there was a motion for post-conviction relief under the Post-Conviction Procedure Act, and that was a continuation of the criminal case. He's a criminal case, it's a continuation of that same case, he seeks post-conviction relief under that same case. It's all the same case. I think that same scenario applies to Zuger versus State versus Zuger, in which it was, again, a criminal matter in which there was an argument that it was...
When you look at the rationale of the court in those cases, it does talk about familiarity of the judge with the case in that type of situation, doesn't it?
There is commentary throughout some of those cases as the familiarity of the judge with the case, yes. And again, I would assert that this is easily distinguishable in the context that this isn't a motion for contempt, a motion to redistribute, a motion to amend the divorce judgment relative to the property distribution. This is an entirely separate case. She's accepted, she has to accept by rulings of the court that there's a divorce judgment in place. That divorce judgment still, as we said here, gave her $242,000 in bails.
The Falcon case, to me, causes a new question. I don't know how they were handled by the court system in 1997 when it was decided, but now a post-conviction relief case must be filed as a separate action, as a civil case, and it comes up separately. And my reading of Falcon was essentially it is a proceeding under the terms of the statute, the demand for change of judge statute. It's considered to be a proceeding. And so Falcon seems to have some pretty good parallels to this, where you had the divorce action, you are now seeking to take action on an item of property awarded in the divorce in a separate action. Why wouldn't we look at Falcon and say there are direct parallels, even though they are separate filed lawsuits? There would be a proceeding.
Yeah, and I guess I don't know, to be quite frank, I don't know the nuances of criminal law. I don't practice criminal law, and I don't know the nuances of that distinguishment there. Having said that, I will go back to the statute ruling that says this isn't, it has to be associated with this action or proceeding.
Right, no, I'm assume I agree with you on matter pertaining. I'm now talking about action or proceeding, and in the Falcon case, this court held that the separate filed lawsuit, I think it was a separate filed lawsuit, it certainly would be today, for a post-conviction relief action, was the same proceeding as the underlying criminal action, for purposes of the demand for change of judge statute. And so my question is, if you accept at least what I'm saying about post-conviction relief now, why isn't that a parallel that's pretty persuasive here?
Yeah, and I guess, Your Honor, my distinguishment would be again, I would go back to the entire separate distinct proceeding here. Those are all criminal in nature. Those are all, at that point in time and at the time of Falcon in 97, that was a continuation of that criminal act. It may be separate now, but we'd have to deal with that. We being, I guess you, the Supreme Court would have to deal with that issue if it was brought up with this court now, because it's been defined presumptively as a separate proceeding. It was not at that point.
I'm trying to see if they had I'm not seeing on the face of the Falcon case whether it was filed as a criminal action. And as I say now, post-conviction would be filed as a civil action.
And that being a nuance and a change in law that's occurred since 1997.
I don't know that it is. All I'm saying is I don't know.
Yeah, and I don't know either, because again, I don't practice criminal law.
When did the Post-Conviction Act become effective?
That I don't know.
If it was before that, it's always been a civil action to replace the writ of habeas corpus.
Yeah, and I know the commentary in the Falcon case is that they mentioned it's civil in nature, but it's not a civil action. It's not a separate civil action. It's a continuation of that same action, is what the Supreme Court commented upon in Falcon. And I believe that the distinction here again is that this is a separate and distinct action or proceeding.
To enforce the judgment.
No, to gain property that was awarded to her under the judgment.
But that, it gets back to the original judgment. That, I have trouble with the statement she was awarded it under the judgment. She was awarded it with some pretty specific conditions. Give Gerald 14 days notice of your intent to remove them, and remove them within 30 days of the judgment. I mean, that's what she was required to do, and in our prior appeal, we affirmed the district court's conclusions and findings of fact saying she didn't comply with the judgment. So how do you go from not complying with the judgment and now you get to start a separate action to essentially avoid the terms of the judgment which required her to remove them within 30 days?
Yeah, I don't think she's avoiding the terms of the judgment, though, Justice Jensen, respectfully. The judgment certainly required her to do that. And had she complied fully with the terms of that judgment, she would presumptively have received those $242,000 in bails. There are now consequences associated with her having not complied with that judgment, including the fact that she has to go through an entire process to try to enforce the rights to the property she has. Gerald Wald's going to be able to come back and argue in the context of an unjust enrichment claim, saying, listen, I have storage costs. There's a deterioration you didn't mitigate your damages. There's a deterioration in the property and assets. He can make those arguments in the context of a current case that didn't apply had she fully complied, and she would receive. So she's going to have damages and consequences as a result of her failure to take actions too within the terms of that divorce judgment. I don't believe that obliviates the fact that she was awarded property, she doesn't have that property, and there's been no court that's found that she obliviated her right to that property. Rather than the finding has been relative to contempt and the failure to show lack of compliance to allow for redistribution. I see my time is up. Thank you, Your Honor.
Mr. Pagel, thank you for your initial argument this afternoon. Ms. Batchelor, whenever you're ready, you can approach the podium and begin your argument.
Good afternoon, Your Honors. Chief Justice Jensen, opposing counsel. My name is Mary Batchelor, and I represent Respondent Gerard Wald in this matter. We are happy today to be able to support Judge Hovey's decision at the district court level, and we ask the court to deny Donna's request to vacate the district court's order, denying her change of judge, grant her demand for change of judge, and assign the instant matter to a new district court judge. And I want to start by really framing the issue as we view it, which I believe is how Chief Justice Jensen described it just now, which is whether a plaintiff can be allowed to simply repackage the exact same claims based on the same nucleus of operative fact and requesting the exact same remedy into a new lawsuit based on different legal theories, and then claim that this is a new and separate proceeding entitling them to a change of judge under the change of judge statute. And we believe the answer to that is no, for several reasons.
If I may interrupt, how should they have done it?
How should they have done it?
If this is her property and she doesn't have it, what should she do now?
You know, unfortunately, I believe that she has exhausted her remedies under the divorce decree. And that is a separate issue that we have currently a motion for summary judgment pending at the district court. But our argument is that Donna was awarded the property, absolutely. She had several legal remedies under the law, which she has pursued. She unfortunately, to her, failed to prevail under those legal remedies. But at this point, she has no more right to that property. And
you don't want us to decide that in this case. The only thing we have before is a change of judge.
Exactly. That is exactly right. And I think that that's a good point that we don't want to get, distracted by, is that the issue in front of the court right now is not whether Gerard had a right to those hay bales, but whether Donna has a right to a change of judge when really all she's asking for is a do-over in this case because she wasn't happy with the original decision.
The prior action, the contempt motion, the contempt wasn't just for receiving the hay bales. It also, in lieu of that, requested a money judgment, correct?
Exactly, yes.
And wasn't part of that earlier decision by Judge Narum that Donna failed to provide any evidence which would support a money judgment?
That's correct.
So it wasn't just turn over the hay bales, it was turn over the hay bales or grant me a money judgment.
Yes, that's exactly right. And that's also part of our argument in terms of, interpretation of the statute as it relates to any matters pertaining to a proceeding that has come before. It doesn't have to be the same cause of action. It doesn't have to be the same lawsuit. And I think that is something that the statute very clearly provides for in its breadth, It doesn't,
I want to stop and make sure I'm clear there. So
Sure.
Mr. Pagel received a question, I believe, from Justice McGevers about how we interpret the statute.
yes.
And I take it your client's interpretation is that any matter pertaining refers to the dispute rather than the lawsuit, is that right?
Yes, exactly. You know, and there's a couple cases that are instructive on that matter, one of which is the case that you all just raised, specifically about Falcon v. State. And you were correct in the understanding that the post-judgment conviction, or excuse me, the post-conviction proceeding is a civil proceeding. So
Well,
the
it's
underlying,
civil-like, the statute says.
okay. But it
Was-
is,
What was the history in Falcon? Do you know? Was it filed in the criminal case?
according to the case law, let me pull that up. A motion under the Uniform Post-Conviction Procedure Act is treated as an independent civil action. That is at paragraph 9. And so the court explains, even though it is civil in nature, as opposed to the underlying action, which is criminal, they call it a continuation of the prior action. And I think the point that you made related to who is best fit to consider the proceeding is really a good one, in the sense that Judge Narum, first of all, as you said, there's no evidence and no reason to believe that he cannot be completely unbiased in this matter. But he, by far, has, you know, a wealth of knowledge on this issue, having seen the original divorce trial, read all the pleadings. There's been several hearings. He's heard lots of evidence. And so he has a very good understanding of what the issues are. I think it would be undoubtedly a waste of judicial resources to bring another judge in at this point and basically rehear this entire issue, because the issues are exactly the same. And again, that's something that we argue on our motion for summary judgment, but it's the same nucleus of operative facts, exactly the same facts. She's asking for the same remedy. And really it is just different legal theories, but different legal theories do not entitle you to another lawsuit. I mean, in terms of, you know, the prohibition against splitting a cause of action.
That sounds like an argument on the merits.
Well, that's, you know, that's probably right. I think that that is something, again, that we actually feel very strong in our motion for summary judgment, regardless of who the judge is in this case. We feel that our legal argument is very strong, but that is not the issue here. The issue here really is interpretation of the statute. And so we think that the fact that the legislature chose to use the term pertaining to, you know, if you interpret that as its ordinary meaning, which is what you must do when interpreting a statute under, you know, Century Code provision 01-02-02, pertaining to means to relate directly to concern, or have to do with.
If we disagree with you that action or proceeding, those three words that follow any matter pertaining to the, if we disagree and say that the action or proceeding is this action, the new lawsuit, does your argument change?
I think it does. I think that if you interpret action or proceeding that narrowly, then our interpretation is incorrect. But I think that given the language that the legislature chose, action or proceeding, not lawsuit, not cause of action, I think it provides the discretion to the district court presiding judge to make that determination. And I think that the fact that the legislature specifically accepted three other types, or I shouldn't say types, specific proceedings as being treated as separate and distinct lawsuits that are not, that do entitle someone to potentially a change of judge, I think that the fact the legislature separated those out shows that they had an intention there to keep the rest of the language broader.
Well, but on that point, when you look at subsection 3, and I think that's what you're referring to, where it talks about child custody and property division, that sort of thing,
Yes.
The second to the last line, so I think it's one big run-on sentence, but anyway, it does at one point say separate from the original action. And so in that section, they talk about which action, original or presumably new.
True.
So should we take any guidance from that?
You know, actually, I think one thing about that that's very interesting is that the way that subsection 3 is written, it says, the fact that the judge sought to be disqualified made any ruling in the original action does not bar a demand for change of judge. It doesn't actually say the demand for change of judge must be granted in that situation. So I think, again, that gives discretion to the presiding district court judge to determine whether the judge can still be denied in that matter.
Have we ever said that there's discretion built into the statute? I know that's been argued, but have any of our cases ever said the presiding judge has discretion to deny a change that's been demanded?
Not that I'm aware in those exact words, but I think the fact that subsection 4 provides the provision that it does, the clause that it does, there's discretion built into it.
Well, isn't that under subsection 6, the other reasons? Isn't that, or am I looking at the wrong subsection where it says it can be invalidated because it's untimely or for other reasons?
I think that's a good point as well. That's an issue that hasn't been addressed as far as the research that I read, that other reasons hasn't been defined, but I think that does provide discretion. So in this case.
Are you arguing here that the court exercised discretion, or that it was not a qualifying disqualification under the statute?
I would say our argument is that it was not a qualifying disqualification under the statute. Because of, as we said, I think it's indisputable, and I appreciate that opposing counsel recognized all of the issues that really cannot be disputed, which are those factual issues as well as the conclusions of law that were made in the district court in the motion for contempt or redistribution of property. Those are the exact same issues and the exact same facts and the exact same remedy that is being brought in this action for conversion or unjust enrichment.
Well,
and so,
as I understand your argument, that any matter pertaining to the action is broader than any matter in the action or proceeding.
Correct.
And so I'm wondering if the concept of collateral attack is informative here. If a subsequent matter is essentially a collateral attack on an earlier matter, is that necessarily the same analysis as whether it's matters pertaining to the prior action?
do you mean, I'm sorry, I'm not sure what you mean by collateral attack, as in a collateral estoppel type
Like
issues?
if there'd be estoppel or res judicata issues that would preclude certain issues or claims in the subsequent action?
I think that that is something to consider. I think that the analysis is similar. I don't think that it necessarily determines the issue here. And I think there are probably situations where the facts are the same, but the issues are potentially different. In this case, really the issues are exactly the same. And I think that it's narrow enough to where we don't have to worry about those collateral issues necessarily.
So is any matter include both factual determinations and legal determinations?
Ruled upon any matter pertaining to the action or proceeding, I think it would be.
So what is the scope of the application? Say in a divorce, one party is awarded an automobile, and that automobile is transferred to the receiving party. And the transferor later damages that property. Would that be, and there's a claim by the transferee against the transferor for damage to the property after the transfer. Would that be a matter pertaining?
I don't think so. I think that would be a separate issue. I think that the legal rights and remedies and responsibilities that arise out of that action of damaging the property did not exist prior to that happening. In terms of when the property was transferred, there was no legal right to, damage for that property. Whereas here, the legal rights and remedies flow directly from the divorce decree, and there would be no legal rights or remedies if it wasn't for that. And
So
those,
what's the distinguishing factor here? So she was supposed to receive the bails, she didn't, they're gone or not available. So if that was the only set of facts, it would be more like my car example, is that right?
I think that's true. I think that's
But
true.
here it's different because of the judgment saying you had so many days to pick them up.
And the fact that the issues were already raised in a motion for contempt or redistribution, and the legal rights and remedies were determined at that time, in terms
So if
of,
she would have not brought the contempt action, but instead brought a separate claim, we could then demand against the judge?
you know, I think that's tricky in this case. I think that, that's something that, I do think that if Donna had brought her motion under redistribution of property, under the subsection 3 that allows for that, she could have requested a change of judge at that time potentially, but did not choose to do that. So I think that, you know, I think it really gets to what Chief Justice said about basically just repackaging and then attempting to, when you don't get the opportunity to enforce the judgment the way that you want to, bringing a new lawsuit to enforce that judgment. And that's exactly.
But wouldn't a simpler rule be to draw a bright line? This is a separate action. And isn't your client's remedy really to assert that this is a frivolous action, recover attorney fees, and address the issue that way? That's a bright line. It's a new action. Nobody has to sift through the old action to figure out what it was. And your remedy is a frivolous action. Isn't that a better, brighter line?
I think that that still allows for a lot of abuse. It allows for a waste of judicial resources. It allows for people to harass defendants. It really goes against the idea that there's one lawsuit and one.
Well, you're still going to have that. It's just going to be in front of a different judge.
But it allows, as in this case, the petitioner to go through the process of the divorce, make the motion for contempt or redistribution, lose, and then appeal it, which she did. She appealed it to your court. You affirmed, and at that point, her rights and responsibilities are decided, and it's over. And instead of accepting that, which is the way that it is supposed to be, right, with the opportunity to appeal, instead of accepting that, now she just has the opportunity to continue to harass the defendant by filing a new lawsuit and going through this whole process, incurring attorney's fees. And you're right, we have actually answered, in our answer, asserted that this is a frivolous lawsuit, but we're still here. You still have to hear this petition. It's still a waste of judicial resources, and it's still an opportunity for plaintiffs to
I think that was the Chief
harass.
Justice's question. Wouldn't it have been less resources just to directly attack the claim on the merits instead of chasing the judge? So in other words, like setting aside the merits, aren't we, back to the question, shouldn't we have a bright line rule that says if it's a separate lawsuit, you get a separate judge if you want one? Why not?
I think that I really think that it's too subject to abuse because it encourages a separate lawsuit. Instead of saying, you're done now, and you have to move forward with the decisions that have been granted to you, and accept the fact that you lost the first time, now you have the opportunity to just create a new lawsuit. And there's other policy issues that implicates, of course, but I think that really, I don't think that having a bright line would necessarily help in this situation. And I think that the Giese case, which came up briefly earlier, is entirely analogous to what we have here, because in that case, the ex-wife was moved to transfer assets that she had been awarded in the divorce decree, and the ex-husband filed a motion for change of judge, arguing that this was a separate proceeding. And your court in that situation held that really it was a proceeding to enforce the divorce decree. And that's exactly what we have here.
But that was not a separate action, is that right? Giese was the same
That's correct.
divorce case,
The
a motion
same
in the
lawsuit.
divorce case.
Yep, exactly, the same lawsuit, a motion in the divorce case.
So how does Giese help you?
I think the facts are very analogous, and again, it's just really the difference between, she's seeking the exact same remedy. And my client is seeking that, or not my client, rather, excuse me, the petitioner is seeking that remedy. The petitioner here is seeking to enforce the divorce decree, period. And she's doing that by filing a new lawsuit, which is wasting judicial resources and allowing her to continue to harass the respondent, where really she lost her motion for contempt or redistribution and appealed it, which was then upheld and affirmed by your court. So it's an analogous remedy. She just brought it in a different lawsuit. And I think that under the statute and the words in the statute provides that it's any matter pertaining to the action or proceeding, not a specific lawsuit.
In Giese, if subsection 3 of the statute was in effect then, wouldn't she have been able to make a demand under the property division portion of subsection 3?
She wasn't asking for a redistribution of property. She was just asking for the property to actually be transferred to her because the husband didn't follow through.
It wouldn't meet the predicate of a modification.
Right. And it's actually the exact opposite of what we have here, because petitioner here is the one who failed to enforce her own rights and is now asking for the opportunity to do so in a separate lawsuit.
Ms. Batchelor, your time has expired. Thank you for your argument this afternoon. Mr. Pagel, you have 10 minutes reserved for rebuttal, so whenever you're ready, you can approach the podium and begin your rebuttal argument.
Thank you.
Mr. Pagel, I have a question. You filed this as a separate action, right?
That is correct.
So how did it end up with the same judge? Is it local, or what happened below?
It's the same action in the same judicial district. It was an action filed in the same judicial district. Let me correct my language here. And by chance, it ended up with the same judge.
Same county? Is this a district that assigns based on geographic area?
I don't know how the assignment falls, Your Honor, I'm sorry. Yeah. But it was in the same judicial district, and by chance, yes, the same judge got assigned, yes. I would be very brief in my commentary. The one thing that I will go back to that opposing counsel struck on is, and that I believe is distinguishable here, and we have an issue with, is that her comment was that this is the same action for the same legal rights that she had that existed at the time of the judgment was entered. And I would assert that she did not have those same legal rights at the time that the divorce judgment ended. She had no right to a claim for unjust enrichment. That property had not been awarded to her. She had no right for tortious conversion. That property had not been awarded to her in the context until the divorce judgment was entered.
You're correct that Counsel, you're correct that her rights have changed. But my question goes back to, you've already asserted the remedies. You've already asserted, first, that you wanted the hay bales, and second, in lieu of the hay bales, you wanted monetary damages. How, other than maybe changing the theory, that's the whole point of your second lawsuit, is monetary damages.
Justice, I believe that the request for redistribution of property could have allowed the district court to do whatever it wanted, had that redistribution occurred. It could have awarded land, it could have awarded a bank account, it could have awarded farm property, whatever it wanted.
But it wasn't just redistribution, and I'm looking at the findings of fact from the original one, and a very specific finding by Judge Narum that in lieu of a return of the hay bales, your client was seeking $242,216. And then in the very next finding of fact, Judge Narum finds that you didn't give me any evidence on the value, so I'm not going to award you any money, or award Donna any money. So he specifically addressed the award of monetary damages in lieu of the hay bales. So what remedy other than a monetary award would your client get in this second lawsuit?
She's, well, in the second lawsuit, to be very clear, she's seeking monetary damages. That's
Which
clear.
she sought in the divorce litigation.
She sought a redistribution of property that could have occurred in the context of monetary damages, sure, or could have been in the context of some equipment, farm property, whatever it would have been.
The finding is pretty specific. I'll read it. Donna seeks an award of $242,216 in lieu of her removal of the hay bales. And that was denied.
I agree that that's the finding in the context of a motion for redistribution of property. And when the case was remanded back to the district court, the case wasn't remanded back with the context you can do whatever you want to. It said, you have a limited purposes of this remand. You get to hear your motion on a motion for redistribution or a motion to hold him in contempt. It wasn't a remand to say, if you have any unjust enrichment claim or tortious conversion claim, et cetera. None of that existed. She could not bring that claim because of this case was at an appeal level and there was a very limited remand that went back down to the district court. She had no right to bring that claim for unjust enrichment or tortious interference at that point, tortious conversion at that point in time. Only after a judgment had awarded her hay bales, and she had the right to those hay bales, and those bales were not turned over, did the first existence of any claim for unjust enrichment or tortious conversion occur. And I would submit that had she desired to not file a contempt motion, she could have certainly did, and anybody could do that. I think any party who's awarded property in the context of a divorce case, if they wanted to make it more complex,
So
it's usually easiest to go back through a motion for contempt.
So let's follow this through again, and here's where I'm worried that your argument goes, and that is, we have a divorce judgment. Let's just skip all the contempt things. We have a divorce judgment, and somebody feels like they didn't get the property that they were supposed to receive under the divorce judgment. Are they now entitled to start separate lawsuits on every piece of property that they claim wasn't turned over by the other party?
Yes.
Okay, so they can have separate lawsuits. For example, I've been awarded the 1995 Ford pickup. I don't feel what was given to me. I have a separate unjust enrichment claim.
Yes.
And then 2 years later, I can file another one for the 1980 Jayhawk camper.
Well, I think you have a problem with the 2 years later filing another one, because I think
6 months later.
Well, yeah, I think you have then a situation where you need to bring those claims at once, and we have separate, we're starting to go down a road in which you say, listen, you don't get to every separate piece of equipment bring a separate lawsuit. But I think if Jane and John Doe get divorced and John Doe is keeping $1 million in a bank account, there's nothing that was awarded to Jane. There's nothing that precludes Jane Doe from bringing an action for theft of property, for tortious conversion, for unjust enrichment, etc., and saying, there's no limitation that says you have to bring this in the context of divorce case. They're converting that property. They're keeping it. If she wants to start, I think the easiest thing to do is to bring it in the context of a contempt motion, and you can get attorney's fees and whatever, and ask for that in the context of the contempt motion. You already have a judge that's awarded it. But there's nothing to say that I'm aware of in North Dakota says that's a tortious conversion. That's unjust enrichment. You're not following the law that says that is her property. And she has the ability, I believe, yes, under North Dakota law, to bring a claim against her husband for unjust enrichment or tortious conversion of that property, because it was not, she doesn't have it.
If we do not recognize the ability to demand a change of judge in this circumstance and reach that ruling because there has been a contempt proceeding, will it encourage or discourage separate proceedings?
Respectfully, I don't think a demand for change of judge encourages or discourages separate proceedings. To me, I don't think that's a significant factor that goes into the consideration of a party that is deciding whether or not to bring a lawsuit. I think that's
If they think they weren't treated fairly in a divorce action, you think it wouldn't wouldn't matter if they're gonna end up in contempt before the same judge or a separate lawsuit before a different judge?
I mean, I certainly, you know, if you have a judge that's on your side and you believe that that judge is understanding the entire context of things, certainly the party who's, you know, trying to bring that contempt motion is, I shouldn't say certainly, likely to stay with that same judge and likely file that motion for contempt with that same judge and want to stay in that. But again, I guess I don't believe that that's a significant factor in the context of, am I going to file this as a motion for contempt or am I going to file this as a separate action?
Punitive damages available in the separate action?
I'm not aware of any punitive damages. Well,
Well, if you have
that'd be a claim to be asserted by, at this point, Donna Wald, then there's been no claim for Donna.
If it's truly a tortious conversion, or, yeah, you could theoretically then plead punitive damages for failing to comply with the divorce judgment.
If she can show that she complied with the punitive damages statute and show intent and et cetera, I guess hypothetically, if they would continue to go down that road. I have no further comments. Thank you.
Okay.
Justice Smith.
Mr. Pagel, thank you for your argument this afternoon as well as your rebuttal argument. Ms. Batchelor, thank you for your argument this afternoon as well. This case will be taken under advisement, as all cases are. This court will be adjourned until 2:45 p.m. this afternoon.